The admissibility of experts' opinions as evidence in court. A witness will be permitted to give an oral evidence and provide documents for the purpose of establishing facts. But he may not have the opportunity to express his opinion. In some situations, courts require opinions derived from observed facts stated by experts in the field. As a result, it becomes important to establish the facts in issue or relevant facts. An expert is someone who, by reason of his or her education, training, skill, or experience, has specialist knowledge of a particular field or discipline beyond that of a layman, such that other people may rely on his or her opinion about issues within his or her area of expertise. Duty of an expert. The case of Davey v. Edinburgh Magistrate, 1953 SC 34, states that the duty of the expert is to furnish the judge or jury with necessary scientific criteria for testing the accuracy of their conclusions from their own independent assessment by the application of these criteria to the facts provided in the evidence. Admissibility of an expert's opinion as evidence in court. R.V. Turner, 1975. An expert's opinion is admissible to furnish the court with scientific information which is likely to be outside the experience and knowledge of a judge or jury. Generally, expert evidence is admissible whenever there are matters at issue which require the input of an expert for their observation, analysis, or description. However, the court has the power to exclude expert evidence in certain circumstances, for example when it deals with matters that are for the judge to decide or if on the facts of the case the judge can form his or her own conclusion without the help of an expert. The court also has the power to reject evidence that is otherwise admissible, for example, if it decides that an expert has not established his independence or has not complied with his overriding duty to the court.